All right, let's jump right in. Today we're tackling South African criminal procedure.
A great choice for a deep dive.
Oh, it is. And you've given us a real mix of stuff to work with here.
Definitely.
Excerpts from the actual Criminal Procedure Act, some real-life case studies, and what looks like a study guide for a university course.
Perfect for getting a good grasp of the system.
Yeah, this deep dive is all about seeing how the system really works, like in practice.
Absolutely. It's a system with depth, that's for sure.
So we're gonna break down everything.
Everything.
From the roles of the courts to those tricky situations around like arrest and prosecution. I'm already seeing, just flipping through the study guide, it looks like South African law has a pretty unique history.
It does. It's a fascinating mix of Roman Dutch and English law, which has, really shaped its character.
Okay, so how does that actually show up in the courtroom?
Well, imagine a courtroom where the prosecutor and the accused, they face off directly.
Oh, wow.
That's a hallmark of what's called the accusatorial system,
Okay.
inherited from English law.
So that sounds kind of intense. A real battle of arguments. So no more of those like secretive trials or anything like that.
Exactly. And this shift highlights a key theme. You'll see this throughout South African law. It's this balance between the state's power to prosecute and the protection of individual rights.
Okay. So speaking of individual rights, let's dive into how the system is structured. Now, the study guide breaks it down into study units, which I got to say is pretty helpful.
It is, it is.
This first one here, it's all about laying the groundwork. The history, the sources of law, and then something called criminal procedure.
Right, like building a house, you need a strong foundation. Understanding the historical roots is going to help us make sense of why things work the way they do today.
Yeah, totally.
What this study unit really wants you to understand is that criminal procedure, it's the set of rules that govern how criminal cases move through the system,
Okay.
from investigation all the way to a possible appeal.
Okay, so lots of steps. It looks like the courts play a huge role. And the study guide, it even breaks down the different types of courts. We've got high courts, regional courts, and district courts. This is giving me legal labyrinth vibes.
Think of it more like a tiered cake, each layer handling different levels of offenses. High courts at the top, dealing with the most serious crimes like murder and treason. Then you've got regional courts, and they handle a range of offenses.
Okay.
And then district courts are for those less serious matters.
So like a legal sorting hat, sending each case to the right courtroom. The study guide actually it gives some examples. It says like shoplifting, that wouldn't end up in the high court. But something like a murder trial, that definitely would.
Exactly. Matching the severity of the crime with the court's authority and expertise.
Okay, that makes sense. So let's move on then to the role of the prosecutor. This is something that I find really interesting. And the study guide, it mentions this idea of prosecutorial discretion. It sounds like they have quite a lot of power in deciding which cases actually move forward.
They do. It's a balancing act. Prosecutors have to weigh the seriousness of the crime, the strength of the evidence, and the public interest. They can't prosecute everything.
Right.
So this discretion helps them focus on the most important cases.
So it makes you think about like all the factors they must be juggling, right? The study guide, it lists things like the age of the accused, their personal circumstances, even the triviality of the offense. Imagine having to make those calls.
It's a heavy responsibility.
It is.
And it actually leads to another really fascinating aspect of South African law, private prosecutions.
Wait, hold on. Are you saying that individuals can actually bring criminal charges themselves? That's wild.
In certain very specific circumstances, yes.
Wow.
So the study guide outlines when this is possible. For example, if the National Prosecuting Authority decides not to pursue a case.
Oh, interesting.
It really highlights the power dynamics at play.
So if I felt really strongly about a crime that wasn't being prosecuted, I could potentially take matters into my own hands. It makes you wonder how often that actually happens.
Right, and what the implications are for the justice system.
Exactly.
It's definitely a unique feature of South African law. And not a decision to be taken lightly either. There are a lot of hurdles to clear, and the study guide goes into detail about the process for private prosecutions.
Okay, so before we move on from this unit, can we break down the key players within the prosecuting authority itself? I'm seeing this document mention all sorts of acronyms like NDPP, DNDP. What does all that mean?
Of course. So the NDPP, that's the National Director of Public Prosecutions, head honcho.
Okay.
Think of them as the captain steering the ship.
Okay.
And then you have the Deputy National Directors, the DNDPPs.
Got it.
They assist the NDPP and exercise some of their powers.
So a pretty clear chain of command, ensuring everything runs smoothly. Okay, let's move on to this next study unit. Now, there's one area here that I am particularly interested in, child justice. It seems like South Africa takes a very different approach when it comes to dealing with young offenders.
Absolutely. There's a real emphasis on diverting children away from the formal criminal justice system whenever possible.
Okay.
In fact, the study guide dedicates a whole chapter to this concept.
And there's even a specific act mentioned in the materials, the Child Justice Act. What are people the key takeaways from that?
Well, it's all about understanding that children are different from adults.
Right.
They need a more nuanced approach.
Okay.
The goal is to address the underlying causes of their behavior, provide support rather than simply punishing them.
The study guide, it actually mentions a range of diversion options. Things like programs run by probation officers, community service, even just an apology to the victim. Really, really interesting.
Yeah, it highlights the focus on rehabilitation,
It does.
giving them a chance to learn from their mistakes and turn their lives around.
Okay.
But of course, this doesn't apply to all cases. For serious crime, and court proceedings are still necessary.
Right, right. But even then, it sounds like the procedures are adapted to be more child-friendly
Exactly.
with a focus on their best interests.
That's right. And the chapter goes into detail about the importance of assessment, evaluating the child's family background, psychological state, other factors, to determine the best course of action. Imagine the responsibility involved in making those decisions.
It's a lot, yeah. Definitely a complex and sensitive area. Speaking of complex, this next study unit tackles arrest and detention, which this seems to be where those individual rights we were talking about earlier really come into play.
Absolutely. And this section kicks off by emphasizing the importance of warrants. The South African system really prefers arrests to be made with a warrant,
Okay.
ensuring there's legal backing before someone's freedom is restricted.
So the police can't just arrest anyone on a whim. What about the exceptions to this rule?
Well, there are situations where warrantless arrests are permitted. Like if a police officer witnesses a crime being committed or has reasonable grounds to believe someone is about to commit a crime.
Okay.
It's about balancing the need to, uphold the law with protecting individual liberty.
Yeah, it makes sense. But what exactly constitutes reasonable grounds in the eyes of the law? That seems like a pretty subjective judgment call.
That's a great question. And the study guide goes into that concept in detail. It's not just about a hunch or a suspicion.
Right.
There needs to be objective evidence that would lead a reasonable person to believe a crime's happening or about to happen.
Okay, so more than just a gut feeling. The study guide probably gives some examples to, illustrate this, right?
It does. It also emphasizes the strict procedures that must be followed even when a warrantless arrest is made.
Like what? What are some of the key things that the police have to do to make sure the arrestees' rights are protected?
Well, they have to inform the person why they're being arrested, allow them to contact a lawyer, bring them before court as soon as possible.
Okay.
It's all about preventing unlawful detention and ensuring due process is followed.
I'm seeing a pattern here. It seems like South African criminal procedure is very focused on protecting individuals, protecting them from arbitrary or excessive use of power by the state.
It's definitely a key theme throughout the system.
Yeah, okay. All right, before we get ahead of ourselves, let's unpack this next chapter in the study unit. It seems to be all about the use of force during arrest.
Yeah, this is a very sensitive area, especially considering South Africa's history.
Right.
The study guide outlines very clearly that any use of force by law enforcement, it has to be proportional and necessary.
Okay.
Meaning the force used must be reasonable and justified given the circumstances.
So no excessive force, even if someone is resisting arrest.
Right. It's a balancing act. The police, they have to consider the seriousness of the offense, whether the person is armed, whether they pose a threat to others.
It's a lot.
It's about making, difficult judgment calls on the spot.
Yeah.
Which is why the study guide stresses the importance of training and accountability for law enforcement.
We even have a case example in the materials that really brings this point home. It describes a tragic incident where a police officer fatally shot a suspect during a chase.
Yeah, it highlights the weighty consequences of those split-second decisions.
It does.
And it underscores why this area of law is so carefully scrutinized, both in terms of the legal principles and their application in the real world.
Okay, so speaking of real-world application, let's move on to the next study unit, which looks at the trial process itself. It looks like the study guide breaks down the procedures step by step for both lower and higher courts. It's quite a journey for both the accused and the prosecution.
It is, and this chapter focuses on indictments, specifically in the high court.
Okay.
So an indictment is basically a formal document. It lays out the charges against the accused, including details of the alleged crime and the evidence the prosecution intends to present.
So it's about ensuring transparency. and giving the accused a clear understanding of what they're up against.
Exactly.
Does the study guide elaborate on, like, the contents of an indictment and how it's served?
It does, and it highlights how this process ensures fairness from the outset. The accused has a right to know exactly what they're being accused of, giving them the opportunity to prepare their defense.
Okay, makes sense. So once the indictment is served, what's next?
Well, the accused appears in court and enters a plea.
Okay.
And they have a few options here: guilty, not guilty, or this fascinating concept of plea bargaining, which actually has its own chapter later in this unit.
Plea bargaining. It sounds like some kind of legal negotiation. What's the gist of it?
Basically, it's a process where the accused might agree to plead guilty, maybe to a lesser charge, in exchange for something from the prosecution, like a reduced sentence.
Oh, okay.
It can be a way to expedite the process and avoid a lengthy trial.
So a bit of a compromise then,
Yeah.
potentially benefiting both sides. But it makes you think about the ethical considerations and the role of the victim in all this. Does the study guide touch on that?
It does. The chapter explores the role of the victim in plea bargaining, highlighting their right to be informed about the negotiations and to express their views on the proposed agreement.
Okay. Good to know the victim isn't completely left out of the equation. It sounds like South African law really tries to balance the interests of all the parties involved, even when it comes to these kind of complex legal maneuvers.
Absolutely. It's a complex dance between competing interests, rights, and legal procedures.
Okay, so let's imagine a plea has been entered. What happens next?
Well, that depends on the plea. If it's guilty, the court might question the accused to make sure they truly understand the charges and the consequences before moving on to sentencing.
So it's about making sure the plea is genuine.
Exactly, an informed decision.
Okay. What if the plea is not guilty?
Then we head to trial,
Uh-oh.
where things can get pretty dramatic.
This is where the prosecution and defense present their evidence,
Right.
call their witnesses, and make their arguments.
Exactly.
Okay, I'm picturing those tense courtroom scenes from legal dramas. You know, the evidence being presented, witnesses being grilled under oath, and everyone waiting with bated breath for the verdict.
Yeah, it can be quite captivating. But, this is real life,
Right.
not a TV show. There are real people and real consequences at stake.
The study guide seems to emphasize that, highlighting how the rules and procedures of the trial, they're all designed to ensure fairness and protect the rights of everyone involved.
Absolutely. The accused has a right to remain silent, to be presumed innocent until proven guilty, and to have legal representation.
What happens if somebody can't afford a lawyer? Does the study guide mention legal aid at all?
It does. It outlines how the state is obligated to provide legal representation for those who can't afford it,
Okay.
ensuring that everyone has access to legal counsel, regardless of their financial situation.
That's reassuring. At least on paper, it sounds like the system is really trying to create a level playing field, which is, so crucial for fairness.
Absolutely. But remember, these rights and procedures, they don't just magically happen.
Right.
They require vigilance, advocacy, and a commitment to upholding the principles of justice.
Okay, before we wrap up this part of our deep dive, I'm curious about one more thing. What happens if the trial ends with a guilty verdict? Is it straight to sentencing? Or are there other options?
That's where things get even more interesting.
Ooh.
And we'll be exploring those options in more detail in our next installment.
Okay.
We'll delve into the complexities of sentencing, the avenues for appeals and reviews, and uncover some unique features of South African law that you just won't find anywhere else.
All right. So until then, keep your legal thinking caps on, and we'll see you back here for part 2 of our South African criminal procedure safari.
Sounds good. Welcome back. Ready for more of South African criminal procedure?
Oh, absolutely. Last time we went through so much, those foundational principles, all the way to, the drama of a trial.
Yeah, a lot to unpack.
But the story doesn't end there.
Oh.
This study guide, it shows that this next study unit dives into sentencing.
Right.
And then the fascinating and sometimes confusing area of appeals and reviews.
It really is like the final act of a legal drama.
It is.
There's still so much to play out.
Totally. And understanding these procedures, it's crucial, not just for legal professionals, but for anyone who wants to really get how justice works in action.
I agree.
I'm noticing right away that this study unit has a whole chapter just dedicated to sentencing.
Makes sense.
It's a big deal. It's the consequences for someone, found guilty.
Exactly. And the study guide, it emphasizes that sentencing isn't just about punishment.
Okay.
It's about achieving various objectives, like deterrence, rehabilitation, and retribution.
Okay.
It's a balancing act, trying to hold offenders accountable, but also considering the needs of society and the victim.
So it sounds like judges have a lot to think about when determining an appropriate sentence.
They do.
What are some of the things they have to consider, according to this study guide?
Well, the chapter lists several factors, things like the seriousness of the offense, the circumstances surrounding the crime, the impact on the victim, and the offender's own personal circumstances.
So not a one-size-fits-all.
No.
They're looking at the individual, the specific context of the crime. Does the study guide, does it give us any examples of the different types of sentences that might be imposed?
It does. It ranges from fines and community service for less serious offenses to imprisonment and even, life imprisonment for the most heinous crimes. The study guide also stresses the importance of considering mitigating factors,
Okay.
like remorse or cooperation with the investigation, things that could actually influence the severity of the sentence.
So there's a lot of nuance here.
Yeah.
A lot of discretion involved.
For sure.
Makes you realize, how much responsibility rests on the shoulders of judges. What's interesting is this unit also includes a chapter specifically on the sentencing of children.
Right. Recognizing that children are, different. They require a different approach. Remember our earlier discussion about the emphasis on diversion and rehabilitation in child justice?
Yeah.
Well, that principle, that extends to sentencing as well.
So even if a child is tried and found guilty, the court's going to look at sentencing differently than they would for an adult. What does this chapter point to as the key considerations there?
Well, it reiterates how important it is to consider the child's age, their maturity level, their developmental stage.
Okay.
The focus is really on finding sentences that address those underlying causes of the behavior
Yeah.
and that support the child's rehabilitation and reintegration back into society.
This study guide actually lists some specific examples of sentences, things that might be imposed on a child, like correctional supervision, which could be like community service or house arrest, even a compulsory residence sentence in a specialized child and youth care center. So it sounds like less about punishment and more about providing structure or support.
Exactly. Giving them the tools and opportunities to make better choices in the future.
Okay, shifting gears a bit here. This study unit, it also gets into this whole world of appeals and reviews, which is something that I think for a lot of people seems kind of shrouded in mystery.
It can be a complex area, but understanding the basics, that's crucial for anyone trying to navigate the legal system. And this chapter, I think it does a good job of kind of demystifying the process.
Yeah, it experienced the different paths available, like if you want to challenge a court's decision. Now, the study guide, it seems to really emphasize the difference between an appeal and a review. I remember we touched on that briefly last time, but maybe could you refresh our memory on the key differences?
Of course. So an appeal that focuses on the substance of the decision. Did the court correctly apply the law? Was the verdict supported by the evidence? Did the sentence fit the crime? A review, though, is more about the process. Were there procedural irregularities? Was there bias? Was something done that, unfairly influenced the outcome?
So appeals, they're about whether the decision itself was right or wrong. And reviews, they're about whether the legal game was played fairly.
Exactly. And the remedies sought are also different.
Oh, okay.
An appeal that might result in the conviction being overturned, the sentence being reduced, or even a whole new trial being ordered.
Wow.
But a review that usually aims to have the original decision set aside or, declared invalid because the process was flawed.
Okay, that makes sense. But who actually has the right to appeal or to see a review? In a criminal case, is it just the accused who can challenge the outcome? Or does the prosecution have a say, too?
Well, the accused definitely has the right to appeal both a conviction and a sentence, but the prosecution, they also have some limited rights to appeal or review certain decisions.
Okay.
This chapter goes into detail about the specific grounds on which each party can appeal. It highlights the legal principles, the procedures involved.
Makes you wonder, what the reasons are behind those limitations. Especially for the prosecution. I'm guessing it has to do with, preventing double jeopardy.
You're right. That principle, it protects individuals from being tried twice for the same crime. So the prosecution, they can appeal certain decisions, but they can't just appeal every acquittal they disagree with.
Right. Okay, so there are safeguards in place to prevent the state from just endlessly pursuing someone for the same crime. But what are some of the things that the prosecution can appeal?
Well, one example is when a question of law has been decided in favor of the accused. Remember, appeals are all about making sure the law was applied correctly. So if the prosecution thinks the judge made a legal error that led to an acquittal, they might have grounds to appeal.
So it's not about just relitigating the facts of the case. It's about, like, clarifying the law and making sure it's applied consistently, like a legal quality control check.
That's a good way to put it. And this chapter also explores the grounds for appealing a sentence.
Okay.
Both the accused and the prosecution can appeal a sentence if they think it's either too lenient or too harsh. But they need to show that the sentence was, like, outside the bounds of what's considered reasonable for that particular crime.
This study guide actually mentions a case where a sentence was deemed incompetent, meaning like the court didn't have the power to give that particular sentence.
Right.
So it seems like those kinds of scenarios, that could also lead to an appeal.
Absolutely. It's about making sure that sentences are not only fair and proportionate, but also legally sound.
Okay, so we've talked about, like, who can appeal, the reasons why they can appeal, but what about the how? Like, what's the actual process for challenging a court's decision?
Well, the chapter walks us through those steps, and in great detail. It starts with applying for leave to appeal,
Okay.
basically asking the court that issued the original judgment for permission to take the case to a higher court.
So you're asking the same judge who ruled against you to give you a chance to appeal their decision. That seems a bit counterintuitive.
It might sound strange, but the judge is looking at whether there are valid grounds for an appeal, like, errors of law, factual misinterpretations, procedural irregularities, that sort of thing. They're essentially acting as a gatekeeper, making sure that only appeals that have merit actually get to a higher court.
And what if the judge, what if they say no, refuses to grant leave to appeal? Is that it? Game over.
Not necessarily. The chapter explains how you can petition a higher court directly, basically asking them to overturn the lower court's refusal. It's a second chance to argue your case, but it highlights the importance of, having a good legal team.
Yeah.
Someone who can navigate these procedures and present a compelling argument.
So let's say leave to appeal is granted. What happens next? Does the whole case start over? Or is it like a more streamlined process?
Well, the chapter explains how the court record from the original trial that gets sent to the higher court, and both sides will have opportunities to submit, written arguments, even present oral arguments before the judges. So it's like a whole new legal battle. But this time, it's focused on the specific issues being appealed.
It's a lot of work.
It is.
For everyone involved.
It's a complex, demanding process, but a crucial one for ensuring that justice is served.
All right, before we move on to our final study unit, I want to go back to something we briefly talked about earlier. Those constitutional guarantees, the ones that protect our rights during a trial.
Right, the foundation of a fair trial in South Africa that lies in the Constitution. And this chapter, it gets into the specific rights that are enshrined in our highest law. It's like a shield against arbitrary or unjust treatment by the state.
The list in the study guide is pretty comprehensive. The right to be consumed innocent, the right to remain silent, the right to legal representation, the right to a fair and public hearing. That's a lot.
It is, and these rights, they're not just words on paper. They have real-world implications.
Okay.
And the study guide explores how these rights are upheld throughout the whole criminal justice process. It emphasizes their importance in safeguarding individual liberty, ensuring a just outcome.
Make you appreciate the framework that's in place, right, to prevent abuses of power and protect those who've been accused of crimes. It sounds like a system that's trying to balance the need for law and order with the protection of individual rights.
Absolutely. And understanding those rights, how they operate, that's key to navigating the legal system and advocating for yourself or for others.
Okay, so we've covered so much in this study unit: sentencing guidelines, appeals, constitutional rights. But there's still more to explore.
There is. Our deep dive continues. Next time we'll delve into some specific aspects of South African law that make it really unique, the way it handles certain legal concepts, how it adapts to, the specific needs of different groups within society.
Okay, sounds good. All right, welcome back for the final stretch of our South African criminal procedure marathon.
A marathon with some really interesting twists and turns.
It has. We've gone from the basics of the system all the way to those super complex trials, sentencing, and even those appeals processes. But our final study unit, it takes us to some pretty specific topics.
Yeah.
Kind of those unique elements of South African law that make it stand out. I got to say, this chapter on competent verdicts, that really caught my eye.
Interesting stuff.
It seems like it gives courts some wiggle room in how they handle those cases where the evidence, it doesn't quite line up perfectly with the original charge.
Yeah, it's a fascinating aspect of South African law. So, a competent verdict allows the court to actually find someone guilty of a lesser or a related offense, even if the evidence presented at trial doesn't fully support that initial charge.
Okay.
But it's not just like a free pass.
Right.
This chapter really stresses that competent verdicts, they can only be used when it's allowed by specific legal provisions.
So it's like a pre-improved list of alternatives
Exactly.
to make sure that the court's decision, it's still grounded in the law. Does the study guide give us any, like, real-world examples of this?
It does. So imagine someone is charged with murder, right? But the evidence presented at trial, it doesn't prove intent to kill, which is like a key element for a murder charge.
Yeah, yeah.
But the evidence does show that the accused acted negligently, and that led to the victim's death.
So they might not be guilty of murder, not in, like, the strictest legal sense, but they could still be held responsible.
Exactly. So in that case, a competent verdict of culpable homicide, that might be appropriate. It's a lesser offense than murder, but it still reflects how serious the situation was.
Okay.
And ensures that justice is done.
And the study guide, it has other examples too, right? Someone charged with robbery could end up being found guilty of theft. Assault with intent to do grievous bodily harm could be downgraded to common assault. It seems like this system, it allows for a more nuanced approach to justice.
Right, recognizing that the real world, things aren't always black and white.
They're not. Okay, so the study unit also, it has a whole chapter on the procedures for handling accused persons with mental illness.
Yeah.
It seems like a super sensitive area that requires a lot of expertise.
Absolutely. The law recognizes that individuals, if they're suffering from a mental illness, they may not be fully responsible for their actions.
Right.
So this chapter, it lays out the procedures for assessing their mental state,
Okay.
making sure that they're getting treatment and support rather than, just being punished.
It's a good reminder that the justice system, it shouldn't just be about retribution.
No.
It's also about rehabilitation
Right.
and making sure vulnerable people are treated fairly and humanely.
Absolutely.
Does the study guide, does it talk about the specific assessments used to figure out, like, if someone's mentally fit to stand trial?
It does, and it highlights the role of mental health professionals.
Okay.
The court can order a psychiatric evaluation
Okay.
to determine whether the person, the accused, if they understand the charges against them and if they can actually participate in their defense.
That's so interesting how the system, it tries to incorporate these safeguards, recognizing that mental health plays a role in legal proceedings.
A big role. It's a complex area, but this chapter, it offers a really valuable look at how South African law tries to find that balance between justice and compassion and understanding.
It really does. As we're wrapping up this whole deep dive, I keep thinking back to that initial idea we discussed about the balance between the state's power and individual rights. It's like that theme, it just runs through everything in South African criminal procedure.
It does, from the way the courts are set up to the importance of those warrants, the protections for children, the provisions for appeals. It's all about preventing abuses of power and ensuring that the process is fair.
We've only skimmed the surface here, but even just this glimpse, it's given me a much deeper understanding of just how complex South African criminal procedure really is.
It is a complex system.
It's a system that's always changing, too. It's responding to the needs of society and the pursuit of justice.
It is, and as you continue exploring this, remember to be critical. Question things, analyze, and engage with the law. That's how you'll really get it.
I love that. Well, thank you so much for guiding us through this incredible journey. I think we both learned a lot. And to everyone listening, we hope you enjoyed it too. We hope you've come away with a better understanding of South African criminal procedure, that delicate balance between law, justice, and individual rights. Keep learning, keep exploring, and we'll catch you next time on The Deep Dives.